Thank you so much, Marita. And thank you so much for inviting me to attend this colloquium and to present this paper. The title of my presentation is Maintenance Matters for Spouses Married by Muslim Rites. Now, I'd just like to go to the overview of what I'll be doing. So that's basically my overview. But by way of introduction, I think it's important to take cognizance of the fact that it's only since the Constitutional Court decision in 2022, which actually declared the Marriage Act and the Divorce Act as being unconstitutional, that Muslim marriages were actually granted some sort of legal recognition. If you look at the position prior to the enactment of the Constitution, we see that Muslim marriages and all the consequences thereof was largely unrecognized and unregulated. And it's only after the enactment of the Constitution that we actually had the ad hoc recognition of some of the consequences of Muslim marriages, but not Muslim marriages per se. And so the question now arises as to how can Islamic law be accommodated within the South African legal system? And in order to do this, I've actually looked at Islamic law, what that entails specifically as it relates to maintenance, and what the South African position is as well. So if you look at Islamic law, and this is taken from the major sources of Islamic law, which is the Quran, and the Sunnah, that is the actions of the Prophet Muhammad, peace be upon him. We see that the duties of the husband would include the payment of dowry, maintenance, provision of suitable accommodation, treating the wife with kindness, displaying equality where the husband has entered into a polygamous marriage. Now, I'm going to be focusing specifically on the aspect of maintenance. And we see that in terms of Islamic law, that the husband has the sole duty of support regardless of the private means of the wife. So this means that the husband has to provide maintenance to his wife in the form of providing her with food, clothing, housing, medical care, etc. And this is so despite the fact that the wife could be wealthy or own property in her own right, she's not under any obligation to contribute to the maintenance of the household. And we also see that where the wife does contribute financially, she may claim these amounts from her husband at a later stage or at any stage. And unlike South African law, we see that this debt which arises against her husband does not prescribe, unlike also the situation in South African law. Now, as far as the maintenance is concerned in terms of Islamic law, we see that this maintenance arises, or the husband's duty to maintain his wife arises as soon as the marriage has been solemnized. So this is irrespective of whether the wife is has started living with him or not, for whatever reason. As soon as the marriage is solemnized, the husband has the duty to maintain his wife. Okay, now we see that in terms of South African law, that very, very different in that there is a reciprocal duty of support that exists between the spouses as soon as the marriage is solemnized. And this is so irrespective of the matrimonial property system that the parties choose to regulate the marriage. We also see that this reciprocal duty of support the parties have a reciprocal duty of support on a pro rata basis according to the respective means, which is very different from the Islamic law position, which provides that, as I've said before, that the husband has a sole duty of support and the wife does not need to contribute. And where she does in fact contribute, she has a right to claim those amounts from the husband. We see that in terms of South African law, it's only where the spouses have specifically included this, the claim for if the one spouse contributes more than their pro rata share, that they can claim, but this has to be done in an antenuptial contract. And we also see that where the duty, in terms of South African law, where the duty to support is not fulfilled, the spouse claiming maintenance can enforce his duty.
Oops,
yes.
Sorry. We are missing your presentation. I don't know why. I don't know. It just says Eugene's document came up. Please just share again.
Okay, I'll just close it and share again. You see it now?
Oh, there Yes. Yes, I can. Thanks.
Okay. So as I said, if the one party where this duty to support is not being fulfilled, the spouse claiming maintenance can enforce the duty of support by instituting a maintenance claim in either the High Court or the Maintenance Court. Now, if one looks at the differences between Islamic law and South African law, what normally happens if the husband having the sole duty of support towards his wife, if the husband fails in this duty, the wife would, in all probability, in practice, then approach maybe an imam or a learned scholar, or maybe the person who married them, and would lodge a complaint that the husband is not maintaining her, and he would then call in this errant husband and chastise him. But there was basically nothing that parties in reality were very reluctant to actually proceed to claim this maintenance in the maintenance court or even in the High Court. So they would approach religious scholars, and if the husband still, if and the religious scholar would then rely on the God consciousness of the errant husband who's not supporting his wife and children, and chastise him accordingly. But if the husband refused to still make the payment, there was basically no legal enforcement where he could be forced to maintain his wife. Okay, so that's a position during the subsistence of the marriage. If we look at the position with regard after the dissolution of the marriage, where the marriage has been terminated by the death of one of the spouses, we see that the surviving spouse here is allowed to claim to be maintained from the estate of the husband for only a period of 4 months and 10 days after the husband has passed away. Now, this is during the iddat period, the period of mourning, and it's only during this period that the wife can lodge a claim for maintenance against the estate of her deceased spouse. This is in the chapter 2 of the Quran, verse 240. Surah Al-Baqarah provides the evidence with that allows the wife to claim, but only for that period of time. And there appears to be no exception to this rule. After consulting various authorities, etc., the claim for maintenance at the death of your spouse is limited to that period of 4 months and 10 days. Thereafter, the rules of inheritance takes place, where the wife is allowed to inherit in terms of the Islamic laws of inheritance, but no further claim for maintenance against the deceased spouse estate. They're once again very different in terms of South African law. We see that the spouse can lodge, once the marriage is terminated by the death of the one spouse, that the consortium omnis vitae and spousal maintenance comes to an end. So that is our general rule in terms of South African law. We have the exception that the surviving spouse can claim in terms of the Maintenance of Surviving Spouses Act against the estate of the spouse. Now we see that although we have court decisions which make allowances for the party, for Muslim parties, for the Maintenance of Surviving Spouses Act to be utilized by parties married in terms of Muslim rights. We see that this, in effect, although the courts have come to the assistance of Muslim couples or the surviving spouse in this particular case, we see that this position is actually contrary to the principles of Islam. As far as maintenance is concerned, where the marriage is dissolved by divorce, we see that here the husband, as far as maintenance is concerned, is obligated to maintain his wife for a period of 3 months after the divorce has taken place. Okay, this is also known as the iddat period, and after the 3-month iddat period has lapsed, we see that the husband now ceases to be responsible for the maintenance of his ex-wife, because they're now regarded as being legal strangers to each other. This is in the case of a revocable divorce. The reasoning being that if the divorce is revocable, the reconcile and the marriage can still proceed. But after that, if the divorce is irrevocable, they would be regarded as the wife would cease to be able to be maintained by her ex-husband. Now, despite the fact that we have this provision stating that the wife is entitled to maintenance 3 months after a revocable divorce has been given by the husband, we see that there are exceptions to this rule. In the case where the wife is, for example, pregnant at the time that the divorce is issued, and in this particular case, the husband is then obligated to maintain the wife until the birth of the child. Thereafter, his duty for maintaining her lapses and comes to an end. However, if the wife is breastfeeding the child, the husband would also be responsible now for child rearing services, and you'd have to pay the wife for breastfeeding the child. If the wife is looking after the child, because that is also one of his sole responsibilities, which I haven't included in this discussion, but we see that the husband also has to pay his wife for looking after the children. Now, we see that at this time where where the divorce does go through and the husband then after the 3-month period has lapsed, the wife then once again becomes the responsibility of her relatives. If she has a father, it would be a father, a son, etc. Okay, and we found that this, in some instances, this can be problematic, because what if the woman doesn't have any parents, she doesn't have male relatives, or she does have relatives, but they are not in a financial position to support her? The next bit would be for the woman to apply for maintenance from the Baitul Mal, which is like a public treasury. As Muslims, each one is you have to pay a tax, which is 2.5% of your salary, or whatever excess profits you have, etc. And this money, this tax, is then paid to this public treasury known as a Baitul Mal, and it's distributed amongst people, the indigent, etc. Now, in South Africa, where we don't have that, works quite well in Muslim countries, but we're living in a country which is not a Muslim country, such as South Africa, this can be problematic. Okay, we also see that at the time of the divorce, the wife is entitled to any unpaid maintenance due to her that accumulated during the course of the marriage. And as we said before, that this is a debt that does not prescribe, and she can then claim this unpaid arrear maintenance from the estate of the husband, ex-husband. Father is also, as I've also already alluded to, responsible for maintaining his children, and he also has to bear the costs of childcare. Okay, now the position in terms of South African law is very different, in that we see that if the parties enter into a settlement agreement in terms of Section 7, subsection 1 of the Divorce Act, or if they can't come to an agreement, then the court will make an order for maintenance in terms of Section 7, subsection 2. Okay, if we look at the, if we draw a comparison, okay, and we see that even with post maintenance differs markedly from that of Islamic post maintenance, differs markedly from that of South African law. We see that that the duty of support in terms of Islamic law terminates after the 3-month period has lapsed. And in terms of South African law, parties can still claim in terms of the maintenance of, in terms of the Maintenance Act, post maintenance. We see that, for example, that although the courts, South African courts have initially allowed lifelong maintenance, there's been a move now to rehabilitative maintenance, where the parties would only be maintained for a specific period of time. So when one looks at maintenance in terms of Islamic law as well as South African law, we see that they are markedly different, and one wonders how Islamic law can indeed be accommodated in terms of the South African legal system. So as for me, we were left with, because on the one hand, we see that women, especially women and children, they are the ones enduring all these hardships, trials and tribulations. So you'd want to, as a practicing Muslim, you'd want to conform to the principles of your religion, but on the other hand, you also have the situation where there are, in reality, these are the hardships that people, that women and children especially, which they face. So when one looks at, so those are all the differences which I now discuss, and one wonders how it could possibly be reconciled, how Islamic law can be reconciled so that it does fit in, or it can be accommodated by the South African legal system. The one common ground that I have earmarked is that of mediation, where because in terms of Islamic law, we see that if a dispute arises, and especially if there's a marital or family dispute that arises, we see that Islamic law makes it compulsory on parties to submit themselves to mediation. If one looks at Surah Al-Nisa, which is chapter 4, verse 35, there the particular what's called an ayat of the Quran of that particular chapter, or verse of that particular chapter, alludes to arbitration. But on closer inspection and closer investigation, we find that what is actually meant is that the parties must, it's compulsory for the parties to submit themselves to mediation before, if it's, for example, a marital issue, before they can get divorced. And we see that Islamic mediation is a well-established process for resolving disagreements. And the definition of Islamic mediation falls very much in line with what the definition of mediation is elsewhere. Okay, having gone through the maintenance bill, we see that that mediation, if it is going to be included in the maintenance bill, because at this point in time, the Maintenance Act does not make provision for mediation as a process of resolving a dispute, but that it is clear that mediation has become a preferred method of resolving family disputes, which obviously includes maintenance matters. So if you look at the Islamic mediation process, we see that what normally happens is that if there is a dispute, the parties will normally, the husband, if it's a married couple, the husband will then get a representative from his family to, and the wife will do the same, 1 or 2 representatives, and then they will go to an imam who is either the person who married them or some religious scholar within the community. And that imam will then try to mediate the matter, the dispute between those parties. I have been on occasion called to mediate matters where the imam has felt that, look, he is not within his area of expertise, and I have been called on to mediate. So it does actually take practice in real life as well. We also see that the publication of the court and its mediation rules on the Magistrates Court also is indicative of the fact that mediation should be used, going towards that direction, that mediation could be used as a dispute resolving mechanism. So we see that in terms of South African law as well, there is now a big move towards mediation, and not just in maintenance matters. I am a court and mediator as well, and we started at the new law courts in Port Elizabeth. There's been a project, a pilot that has been started, and for about 18 months to 2 years, I mediated on a pro bono basis for matters referred to from the Magistrates Court.
You have a minute left.
In conclusion, I'd like to state that the comparison between Islamic law and the South African legal system demonstrate that, whilst there is some underlying principles that are similar, the rules and principles in Islamic law are clearly fundamentally different from that of South African law. And that's why I posed the question arises whether Islamic law can indeed be accommodated. And we see that even though the courts have in the past been prepared to come to the assistance of couples married in terms of Muslim rights, the decisions of the courts has not always been Sharia compliant. That's my at the end of my presentation. Thank you very much.